record. I've removed my packet, so if anybody has layers, want to remove, feel free to do that.
I need to layers, I need something else.
Are we missing anyone?
I think
Do we need to leave the door open, or do we need to shut it?
yeah, perhaps. Probably
Strong
shut it.
preference?
Why don't we shut it? I'll write it down for you.
Okay, we're back on the record, and I think we were in the middle of cross-examination of Mr. Lennon, so we're on. Yes, sir. Counsel?
Okay,
You may proceed.
thank you. So Mr. Wedland, we were visiting a little bit about that final compliance check that the DEQ will do prior to issuing or denying the application, correct?
Yes.
Okay. Are you aware of a portion of your rules that talks about this final compliance check?
Could you please provide a reference?
Sure. So this is let's start here. So I'll open up chapter 12 of your rules. Does this look familiar to you, this page displayed on the screen?
Yes, it does.
Okay, could you read the title of this chapter?
Procedures applicable to surface coal mining operations.
Okay. And I'm going to go to page 15 of the PDF. And this is in the part of your rules that talks about the applicant violator system. Does this look familiar to you?
Yes, it does.
Okay. Sorry, let me actually scroll it so you can read the whole thing. So would you agree with me that it says, after the applicant completes the above requirements, the DEQ shall request a compliance history report from ABS to determine if there are any unabated or uncorrected violations that affect the applicant's permit eligibility in subsection Romanet 10 above. The DEQ shall request this report no more than 5 business days before a permit is issued. And then further it says, if the applicant is ineligible for a permit, the DEQ shall send you a written notification of the decision and will detail the reasons for ineligibility and include notice of appeal rights. Does that look correct to you?
That's correct.
And you're familiar with that section?
Yes, ma'am.
Okay, so let's go back to the question I asked on, you do this final check and there's outstanding violations, what do you do?
We will not approve the permit action.
And would you deny it at that point?
At that point, we would send a letter that it's denied and can't be approved. Yeah.
Okay.
Yes, that's correct.
Okay, great. Your earlier testimony with Mr. Casti, you were talking about that final compliance check for the permit renewal application, right? Do you remember that testimony?
Yes, it is.
Okay, and that there's this document that has this final compliance check, but you can't find it? Is that correct?
That's correct. It's misplaced at this or misfiled at this point.
But you clearly remember instructing Ms. Romero or somebody else to run that final check?
Yes, I do. Ms. Romero ran that and actually brought it in, and I believe she watched while I reviewed it.
Okay, and you don't know where it is?
At this point in time, it's probably my fault. I probably misplaced it somewhere. We've not been able to locate that document.
Okay. Do you remember the date that applicant violator system check was performed?
It would have been the day before the day of the approval, and I believe that was on or around October 23rd, if I remember right.
Okay, so it wasn't 5 days before?
It would have been, we typically run them the day of or the day prior.
Okay, but this rule that we just talked about, doesn't it say 5 days before?
We do it the day of or the day before again because it's that snapshot in time, and that is at that point in time when we're ready to sign the document. That is the most current run of the list.
Okay, so no more than 5 days and you run it the day before?
Right.
Okay. And is there an electronic copy of that record? When you run that ABS check, how does it, sounds like it was a paper record, but is that typical?
Typically, it is a printed paper record, and then for us to enter it in an electronic format, we would scan it.
So Ms. Romero requested from OSM and actually mail you a hard copy?
It comes in on the screen and you can print the screen.
Okay. So, but there's no way to electronically capture that screen at that time?
I would have to verify that with Ms. Romero because she's the one who's authorized on that system and when she's instructed, she runs the verification and, I see the paper copy.
Okay. All right, so let's go back and revisit that phrase that you and Mr. Cassidy were talking about a violation being corrected to the satisfaction of the authority, department, or agency which has jurisdiction over the violation. Are you familiar with this section of the Environmental Quality Act?
Yes, I am.
Okay. So you previously testified that it's your opinion that if a violation, you run these ABS checks, and if a violation comes back as conditional, you can move forward and process a permit, right?
Yes, that is correct.
Okay. Can you point me to a section of the DEQ regulations that define conditional?
No, I cannot.
Can you point me to a section that defines outstanding?
No, I cannot, and we rely on the Office of Surface Mining Reclamation and Enforcement's oversight definition in their handbook for that.
Okay, but there's not a federal regulation that defines conditional,
Not that I'm aware of.
or a federal regulation that defines outstanding?
Not that I'm aware of, but we do rely on OSM's interpretation and guidance on that.
Okay. So you're a regulator, Mr. Wetland. What does has been or is in the process of being corrected mean to you?
It means you have come to some arrangement or agreement or potentially are in an appeal.
And so if you're in an appeal, that's being corrected?
It can be. That's certainly a path of one of the paths that's available to an operator to pursue.
But you, as a regulator, would you consider that to be being
Yes.
corrected?
Yes, I would in process that, which is what the handbook structures or states.
Okay. Can you point me to a section of the DEQ regulations that define unabated?
There is a section on, not on unabated, but I believe for willful and those definitions I think that's in chapter 16, I'm trying to remember, but can't tell you off the top of my head.
Okay, but not, sorry, not for unabated?
Without having the book in front of me, I can't answer that.
Okay, how about uncorrected?
I don't believe so.
Okay. So we just talked about this a little bit. If the company appeals the violation, that's okay? That makes the violation conditional?
It can be in process, that's correct.
Okay. In the course of your review of the applications to transfer the permits, did you contact or did you instruct anyone else at DEQ to contact the regulatory authorities in the states where the violations were issued to determine if those regulators believe the violations were being corrected to their satisfaction?
No, we did not, because we rely on the ABS system and OSM's production of that information for us. And I am not an expert in particular in Appalachian regulatory law, so I defer to the oversight agency and their analysis of that.
Okay, so I'm pulling back DEQ Exhibit 11. Does this document, I'll let you find it in the hard copy, because that text is really small up there. This document look familiar to you?
Yes, it does.
And you were talking with Mr. Cassidy about it earlier today?
Yes, we will.
Okay. So I'll go to page 3 of this exhibit. At the very bottom, and you and Mr. Cassidy were visiting about this narrative, right? Can you tell me what that last sentence in that narrative says, starting with the word please?
It says, please use the contact information below to verify the conditional status of the violations within the states.
Okay, and there's regulatory contact information for those 3 states, right?
There is.
Okay, so for Kentucky, Virginia, and West Virginia, because those are the states that there are these violations related to those states,
There
right?
is.
So it says, please use the contact information below to verify the conditional status of the violations. And you're just talking that you rely on this report to determine that conditional status. So why didn't you contact these other regulators?
We contacted OSM directly, and I had those discussions with OSM staff to state, are there other concerns or things that I know I'm not aware of, should be aware of? And is there a reason for me not to move forward on these conditional status? And that answer was, no, there are not.
Okay, but isn't this OSM telling you to please use the contact information below to verify the conditional status of the violations with the
It
state?
says you can. I went to OSM directly.
But it says please use.
I think that's Shane.
Yeah.
Oh,
Shane, can you put your phone on mute, please?
yeah.
Okay.
I would read the please use as a please use, but it's not a shall.
Okay. All right, Mr. Wetland, so we're gonna go back to page 1 of this ABS report. And on the first page here, you see this phrase it starts with caution in all capital letters. Do you see that?
Yes, it is.
Okay, could you read that paragraph to me, please?
Yes, caution, the applicant violator system is an informational database. Permit eligibility determinations are made by the regulatory authority with jurisdiction over the permit application, not by the ABS. Results which display outstanding violations may not include critical information about settlements or other conditions that affect permit eligibility. Consult the ABS office for verification information prior to making a decision on these results.
Okay, so you're saying you're relying on the ABS system report, but doesn't this say that you shouldn't actually rely on it? You should do some other due diligence?
That is what that states, but what we've done in practice, and as I've indicated, is we conferred with OSM personnel. They conferred with their office and headquarters to verify if there were things that we should be concerned about or not, and the answer was no.
Okay, but again, you didn't contact any other state regulator?
No, we rely on the oversight agency because, again, it scans the national system.
Okay. So I'm going to pull up DQ Exhibit 8. I'll give you a minute to get there. And do you remember talking with Mr. Cassie about this exhibit?
Yes, it is.
Okay, what is this exhibit? We didn't really.
Guidance or handbook and how to use the ABS and what the terminologies mean.
Where does it say handbook on here?
It does not.
Doesn't it say ABS Office User Assistant Liaisons?
It does, and that's for like my staff that is signed on in the system.
Okay, and so this is the only handbook that you have for the ABS system
This is the guidance we currently have, yes.
from OSM?
Mhm.
Okay. I'm going to turn to page 4 of this exhibit. And you and Mr. Casti, if you scroll down, you'll see conditional violations, all cap, bolded, underlined. You and Mr. Casti were talking about this too, right?
Correct.
Okay. So let's go down here. Would you agree that it also says conditional, so second sentence, conditional means that based upon an agreement or other circumstance, the violation may not cause the state with jurisdiction to immediately determine permit and eligibility?
That's what the statement reads.
Okay, so it has the word may in there, correct?
Correct.
Okay, and then the last sentence, this is the person to call to check whether or not the violation is still considered conditional. Would you agree it says that?
Yes, that's correct.
So why is that in there if you're not actually supposed to call that person?
Again, our practice is to deal with the oversight agency directly and OSM because it's not uncommon for us to have operators in multiple states and multiple jurisdictions.
Okay, but why, this is the handbook from the agency that tells you how to do this. And they're saying this is the person to call to check whether or not the violation is still considered conditional. Why do you think they have that in there?
I have to object. This witness does not have the ability to guess at what other people think. Shouldn't be asked to speculate
Okay.
in that regard.
I'll rephrase, that's fine.
Okay.
Yeah, no, I would agree with that, and I'll rephrase. So just to be clear, Mr. Wetland, so no one, either you or anyone else in DEQ, you didn't contact these regulators in Kentucky and Virginia?
No, we contacted the oversight agency directly, and that's on the first page I will just reference back. It also says their field offices, their units, and their regional solicitors, so they're all aware of this.
Okay, and you
So
talked,
that is the third-party credible source that's audited.
okay, so you talked a little bit again about, you rely on OSM for this data. Are you aware, does OSM have primacy in Kentucky? Or are they the regulator, I should say, I'll rephrase, does Kentucky have primacy to implement their own rules and regulation in Kentucky?
I believe that OSM is still the regulator in Kentucky. I'd have to look on the list. I really don't track Appalachian states. I focus on Wyoming.
Okay, so let's focus on Wyoming. So say there was a violation in Wyoming, would OSM be the party that determines whether that violation is conditional or not, or is it you as the state regulator here in the state?
We would determine that, and OSM would have some level of concurrence with that.
Would they how do they have that concurrence?
Again, when I asked for guidance from the OSM field and regional offices, that's why we go back and ask them those questions, is they're the ones who coordinate in the oversight agency. And if those violations are being contested or there's some major issue, they will be aware of it.
Will they? They'll be aware of all of these 42 violations and the status of them.
That would come in from their regional office. And as it says here, these offices are knowledgeable of these reports and this guidance.
Where does it say that?
On the very front page where it says on the assistance liaisons, contact informations are the field office for OSM, the OSM, other OSM units, and the office of the regional solicitor.
Okay, but doesn't this document also have state regulatory contacts?
It does.
So we talked a little bit about that you didn't talk to the state regulators. Did you talk to anyone at Blackjewel about these violations and their status?
I believe there is a letter that was referenced in the earlier direct testimony that we had sent a letter to the operator indicating that there were problems in the ABS.
In January 2018 of this year.
You would have to reference the exhibit.
Okay, are you aware of any other communication with Blackjewel about these violations?
Not that I'm aware of. I believe that was the time that we let them know that there was potentially some issues out there.
So there haven't been any meetings or other phone calls or anything that you're aware of talking about these violations?
Not that I'm aware of.
Okay. Mr. Wetland and Mr. Casty were talking about something called a schedule listing all notices of violation, right?
Correct.
It's a part of the permit application.
Correct.
Okay. So I'm going to go to DQ Exhibit 2, which is the big one, or one of the bigger ones. And let me take it there, Mr. Wetland. Are you there?
Yes.
Okay, and could you refresh the council what this exhibit is?
This would be the permit transfer application for the building.
Okay. I'm going to go to page 29. I'll give you some time to get there. And it would be helpful if you turn around so yeah, you can see it. And Mr. Wetland, are you familiar with this table?
Yes, I am.
And what does it show?
That's the 3-year violation history for the Bel Air line.
Okay, so this is that schedule listing all notices of violation, right?
Correct.
Okay. So what's depicted here, is this just about that one mine here in Wyoming?
This would be the Alpha operation, when Bel Air was still owned by Alpha back in, looks like 2015.
Okay. Are you familiar with the parts of your rules that talk about what this schedule of violations has to contain?
Without looking at it directly, I can't speak to that. I would have to have the book in front of me. I
Okay.
deal with so many regulation rules on a daily basis that I don't refer to those items from memory.
Okay, sure. So let's talk about this violation. So it has the permitting name on it, right?
Correct,
It has the permit number, right?
correct,
Has an MSHA number,
correct,
an NOV number,
correct,
specter name,
correct,
date issued,
correct,
status,
correct,
violation activity description,
correct.
okay? And then there's a phrase on there, abated, terminated. Do you see that?
Correct.
Okay. So Mr. Wetland, we talked about these 42 violations. Why aren't they on the schedule?
Because they're listed in the ABS system.
But isn't this a part of the permit application? It's in your rules, chapter 2. We were just talking about permit application requirements.
There's no requirement in the rules and regs that specifies whether the operator, whether the agency can produce and review that list. We feel that the third-party analysis is valid and probably more independent.
Okay, this is the permit application that went to public notice, correct?
That's correct.
So I'm a member of the public. I reviewed this. How do we know this is complete list of violations? It doesn't include those 42 that we've been talking about.
The ABS is part of that record.
Is it part of the permit application that goes to public notice?
It is. It's part of the record. When the final, as we said, when those final checks are run, they're placed in the file.
No, when those final checks are run, they're placed in the file.
Mhm.
Okay.
Because that's the snapshot that we're looking for, the most current one.
Okay, so you as a regulator basically amend this part of the permit application with the ABS check that you run.
That's one way to phrase it. I would say that we run the third-party independent review and include that with the file.
But isn't it a requirement for the permit application, this 3-year violation history schedule?
It is, and that's why it's part of the file at the final check.
Okay, so, but is it part of the permit application?
It is.
It is, so
Yes.
the DEQ amends the permit application effectively with that ABS, is that what you're saying?
Yes, because that's the most current snapshot of the violations.
All right. So, Mr. Wetland, we talked a little bit about the phrases in the applicant violator system, conditional and outstanding, right?
Correct.
And that those aren't defined in your rules and regs.
Correct.
Okay, and then we've talked a little bit about the phrases corrected and abated, right?
Briefly, yes.
And that those are phrases in the Environmental Quality Act.
Correct.
Okay. And we talked a little bit about this, but in your opinion, is everything that's conditional corrected and abated?
In my professional opinion, if it is in a conditional status, makes that the application is eligible to be moved forward.
Okay, but let's look at this violation history again up on the screen. And that status that we were talking about, it says abated/terminated, right?
Correct.
So that's different than conditional, right?
Correct. This one is completely closed.
Okay, and it says abated/terminated.
Correct.
So, for instance, let's say this, in this particular situation, maybe the permit applicant had just appealed the violation. Would that be captured, do you think, in the violation activity portion of that schedule?
I believe it would say that it's at that point in time either in process or not total in abatement.
Okay.
I can't speak to the status or how they list the status of those in other states.
Okay. So just to capture, is that violation activity description, do you get that from an AVS report?
No, we do not.
Okay, so if this is a requirement that it's part of the permit application to have this violation activity description, how is the AVS report meeting these requirements for permit applications?
Would you please restate that one more time?
Yeah, sure. So we're looking at the schedule of violations, and we've been talking about that it's just for the mine here in Wyoming. It doesn't include these 42 others. And you're saying those 42 others are supplemented from the AVS check. Does the AVS check contain everything you need for this schedule?
I believe we're talking about two items here. The schedule that you're looking at here is the schedule for the violations within the state. And the AVS check is looking on the national scale for that analysis. And that is why we use that AVS system, is we can't speak to those other states. So I believe you're talking about two separate documents here.
Okay, but Mr. Wetland, doesn't this schedule require listings from any subsidiaries, affiliates, or persons owned or controlled by or under common control with the applicant or operator?
Yes, and those are in the AVS. That's why you saw if we go to that document, you would see the listings for Revelation and Keystone.
Right, but you don't see it in the schedule.
Again, this is only one part of that, of all of that information. And this schedule is Wyoming's schedule of violations. The AVS is the national schedule of violations.
Where does it say in your rules that this schedule is just for Wyoming violations? Do we just talk about ownership and control?
I don't understand your question there, Ms. Henderson.
Where does it say in your rules that this schedule is just supposed to be for Wyoming mining operations?
This is, again, I'm going to go back to what I've previously stated. There's two pieces to this. Wyoming may generate more detailed information than the AVS, but the AVS still addresses the national section of violations.
Okay, well, Mr. Wetland, your rules call for a
I
complete.
cannot run our state requirements on West Virginia.
Okay, that's fine, Mr. Wetland. But let's go to your rules requiring a complete statement of compliance, including violations for persons owned or controlled by or under common control with the applicant or operator.
I believe both of those documents together meet that requirement.
Okay, so you believe the AVS check that we were just talking about, DEQ Exhibit 11, meets the requirements in your rules?
I do.
Okay, I think we have a difference in opinion on that. All right, let's go back to a conversation we were having about if there are these conditional violations on the AVS check, right?
Correct.
Okay, are you familiar with the part of your rules that talks about a provisionally issued permit?
Without looking to the specific line item, I would say I'm generally familiar, but I would need the document.
Okay, let's go to chapter 12 of your rules and we can pull them up. So for the reference of everybody, this is chapter 12. And I'm on page 13 of that rule package. I won't bore you with me trying to find exactly where this is in the rules, but it's on page 13.
12-13.
Yeah, page 12-13 of the chapter 12 rules. And it's something called capital D exceptions. And we're talking about an applicant may be eligible for a provisionally issued permit if the applicant owns or controls surface coal mining and reclamation operations with a notice of violation. Are you familiar with this kind of provisionally issued permit requirement?
In general, but in my tenure at the agency, we've not issued one of those.
Okay. So we talked a little bit about that an applicant can get a permit if there's it's conditional, and the applicant can get a permit if it's just appealed, right?
I would clarify that to say that appealed can get a conditional status
Okay,
if they're in an appeal process.
okay, that's fine. Are you aware of the portion of your rules that talks about if there has been an appeal, but unless there is an initial judicial decision affirming or finding that violation, that you're supposed to issue a provisionally issued permit?
Mr. Henry, I'm going to interpose something to the benefit of everyone. If we're going to talk about a particular section of the rules, it might be helpful for us to just cite the specific rule section so we can all find it. Having a little bit of difficulty with the assertion followed by a question would be just, I think it'd be helpful to know which section we're talking about.
I think council is preparing to do that, so if we do that would be helpful.
Yeah, I appreciate that.
Sure.
Just for the record, though, our projector, which contains some of the exhibits up here, linked off and put back on again,
Oh,
some
sorry.
weather-related
Oh.
issues, but it appears to be working.
Okay. I will, for the benefit of everybody, I'll pull it up on the screen too, where we are. Okay, so I have to find it. So it's, I think we're still in section 1. Okay, so section 1 of chapter 12. And we're down to should actually just find this somewhere. Trying to find the little. Okay, Romanette 7, I think. Right. Romanette 8, capital D.
Give us a page, council.
Oh, sorry. So Romanette 10, actually, and capital D, and we're on page 1213. 12-13. We're still 12-13. I just am trying to find exactly. It's a huge section of regulations that aren't that easy to navigate. Okay, so exceptions. And Mr. Wetland, I'm here at 3. And it reads, an applicant is eligible for a provisionally issued permit if the applicant is pursuing a good faith challenge to all pertinent ownership and control listings or findings under Chapter 12, Section 1, or administrative or judicial appeal of all pertinent ownership or control listings or findings, or contesting the validity of a violation unless there is an initial judicial decision affirming the listing or finding or the violation, comma, and those decisions remain in force. Are you familiar with that section?
Yes, I am.
So there's these 42 violations that are conditional. Do you have any idea of how many of them are just conditional because they're in a status of an appeal?
My response to that is that what we stated was that for the transfer, it was technically suitable for the document to go to publication, and I believe this section is referencing at the time of issuance of a permit, which has not occurred.
Okay, but are you aware of out of these 42 violations, how many of them are conditional merely because they've been appealed by the applicant or someone under ownership and control of the applicant?
I've not gone into that level of detail. Again, we rely on the ABS and OSM as the oversight agency,
So are you aware
For
whether you need to
determination.
issue?
and we aren't at this phase in the process yet.
Okay, but you will be at this phase in the process presumably soon, correct?
Correct.
And at that point, are you going to be aware of how many of those 42 violations have become conditional merely because they've been appealed?
We will take a look and we will consult with OSM.
You'll consult with OSM, but will you go back to those regulatory agencies and get that information?
We will consult with OSM.
Does OSM have that information?
We will consult with OSM.
Okay. Mr. Wetland, do you know if you'll have to issue a provisionally issued permit, or can you actually issue a whole permit without a provisional requirement?
Can't speak to that today. I don't know where we're gonna be at that point in time in the process.
Have you personally, as the administrator of the Land Quality Division of the Wyoming DQ, ever issued a provisionally issued permit?
Not in my tenure at the agency.
Okay, but it is something you're aware of and would do presumably if you found out that one of those conditional violations were conditional merely because they've been appealed?
It would be an option that we would consider at the time.
It'd be an
But
option,
we aren't at that point in juncture
okay?
yet in the process.
But you don't see it as a requirement?
Again, we're just not at that point in the process.
You're not at that point in the process. Okay. Are you aware under this provisionally issued permit provision of your rules, can it just forever be provisional, or is there a time when it becomes, like, that provisional word is taken off of the permit?
My answer to that is, again, we're not at that point in the process, so I really don't have a way to tell you today what that would look like or what that would be, and I've not issued one of those at this point in time in my tenure at the agency.
Okay, so yeah, you're just not sure because you've never done it before.
We're not there yet.
Okay.
And when we get there, we may or may not have that issue to deal with. I can't answer that question today.
Okay. Do you think it's important for the purposes of public notice and comment that you knew that answer before public notice and comment?
I don't believe so, because the public notice and comment, we relied on the ABS, we consulted with OSM, and it went out for publication.
So you're not aware whether under public notice and comment provisions in that public notice, you would have to say if the agency is planning to issue a provisional permit?
We don't know that answer today. We know that based on the ABS check that we relied on, and under the provisions and requirements thereof that we've stated meet the requirements, we had no reason to not go to public notice with this permit.
Okay, and as we talked about, that ABS check doesn't actually talk about the status of the violation, right?
Objection, it misstates content of all these ABS checks would say on their face the status of the violation.
Join that objection.
Okay, let's talk about it a different
Something
way.
like, record counsel, you want to rephrase the question? Is that right?
Sure, that's fine, I will do that. Does the ABS check that you've mentioned talk about something called a violation activity and kind of history of that violation?
It does not. It lists whether it is outstanding or conditional.
Okay, that's great. Okay, so Mr. Wetland, as a regulator, you've mentioned that you've never issued one of these provisional permits, right?
That's correct.
Have you ever seen an ABS check with 42 violations?
I have.
Okay.
And considering the number of mines and permits that these operators hold, it's hard to say. But in my time in both industry and as a regulator, I've seen multiple violations.
Multiple violations, but 42?
Yes,
You've seen more than 42?
yes,
Okay. Does that number concern you at all?
no.
It doesn't. Okay. All right, let's move on. Did you, or to your knowledge, anyone else at the department review or receive any information on violations issued by the Environmental Protection Agency during the scope of your compliance review?
No, we did not, and we do not have authority over those such violations.
Okay. Mr. Wetland, so for purposes of everyone, you can either pull this up in your statute book or actually have copies for everyone. Actually, no, this one.
Is this, have you marked this?
I have not, but I can. It could be a demonstrative exhibit if that makes sense to you.
That's sort of section?
Yeah, it's a statute section. I just have it broken up. Here, I'll give you the rest. Thank you, Jim. So, Mr. Wetland, this is section 406A Romanet 14 of the Environmental Quality Act. Are you familiar with this section?
Yes, I am.
Okay. Are you familiar with the phrase in this section that says, of any department or agency in the United States pertaining to air or water environmental protection?
I am.
Do you think that means the Environmental Protection Agency?
For the purposes of the coal program, we rely on the AVS system for those violations because those are the violations that we would have any level of authority to have any interaction with.
Okay, does the AVS system include violations from the EPA?
No,
Does it include violations of any other state DEQ, air or water agency?
No.
In Kentucky or West Virginia or Virginia?
no.
Are you aware that those state regulators in those states think about the Clean Water Act and violations of companies?
I can't speak to what they're aware of or how their regulations are written for their own regulatory authorities in their own states.
Are you aware that Revelation Energy has Clean Water Act violations?
I'm generally aware that those are out there.
They're out there. So when we talk about agencies or departments that regulate air or water, environmental protection, is that the Land Quality Division of the DEQ?
My quality division is not encompassing of air and water.
Right, so it's not. So how do you check that air and water provision of your statute if you don't do that work?
Again, we rely on the ABS.
But we just talked about the ABS doesn't include these violations.
I can't say how those individual states and their agencies are structured and what they do or do not do.
Okay, that
So
doesn't
I rely
answer.
on the national database from OSM for that information.
And Mr. Rutland, that doesn't answer my question. If the statute says that you have to look at violations pertaining to air or water quality, how do you do that?
Through the ABS system.
But they're not in there.
Can't say whether that's under Kentucky or West Virginia or their programs, how they're structured.
Okay, but you're aware that EPA violations aren't in the ABS system.
That's correct. And again, I would state that I have no authority whatsoever over any of the EPA violations or their administrative orders of consent.
And Mr. Rutland, that's not what we're talking about. We're talking about your authority to issue or deny a permit for a coal mining operation. Do you have that authority?
The director has that authority.
Okay, but you have that regulatory review process prior to Director Parfit actually signing or denying a permit, right?
Correct.
Okay. So, and you testified that you do this compliance check. You're the one that is in control and it's your check that you do.
I am.
Okay. Does this provision say that you actually have to address those violations? Or does it say that you just have to know whether they exist or not?
It says whether we have to know whether they exist or not.
And don't you have the ability and the regulatory authority to do that?
We do, and we do that via the AVS program.
But these violations aren't in there.
Is that a question, Council?
Yeah, I mean, I think we've established it, so maybe I'll move on. Is there any other information besides this AVS check that you rely on, and whether this compliance check part of the statute's being met?
We rely on our own survey of our violations within the state, as you've seen in your exhibit, and we rely on the AVS check because that is the national database by the Oversight Agency for Coal.
Okay, well, let's focus on Wyoming. So do you go over to Administrator Frederick's office at Water Quality and talk to him about whether there's any outstanding violations?
No, I do not.
Do you go over to Nancy Beer's office and talk to her whether there's any outstanding air violations for these fines?
No, I do not.
Okay.
Sorry. Thanks, Kathy.
Okay, so you don't actually check whether any department or agency in the United States pertaining to air or water environmental protection has issued any violations to this mining company or anyone under ownership or control, correct?
Again, we rely on the AVS system.
And does OSN regulate air, water protection?
Not to my knowledge in those states, but again, I'm not an expert in regulatory law in West Virginia, Kentucky, Tennessee, Virginia,
But you're,
Ohio, Pennsylvania.
okay, does OSN issue permits under the Clean Air Act?
No. not
Do
that
they
I'm
issue
aware of.
permits under the Clean Water Act?
No, not that I'm aware of. You'd have to have either primacy of your program to do that.
Okay. All right, knowing this will draw an objection, does DEQ check to see if there are any unabated or uncorrected violations from the Mine Safety Health Administration?
No, we do not, but the MSHA ID numbers are listed in the permit such that that search can be run if necessary.
Okay, I mean, would you run it?
No, because I have no authority there as well, and I would rely on the state mine inspector if he chose to run that analysis or not, where they have authority.
Okay, but so you just said that that MSHA number is in this violation history for that very purpose, so you could run it. You need to reread your
If I,
answer that?
if I chose to run that, if we chose to go beyond that, I can go to the website and run it at any time. Again, that number is in there, so the state mine inspector who has authority over that can go in and look at that and see if there's things that they need to be concerned about or MSHA on a regional
Okay.
basis.
Do you regularly consult with the state mine inspector when you're reviewing this violation history table?
No, not necessarily.
Not necessarily, or have you ever?
I have inquired about a safety violation on 2 occasions that had environmental implications associated with it.
Okay. How do you know that they had environmental implications if you don't actually go talk to that state mine
Because the
inspector?
violations were found by our agency,
How were they found?
by our inspectors. Because we inspect a number of these mines, non-coal as well as coal, on a monthly, annual, quarterly, semi-annual basis. And the state mine inspector, the MSHA ID numbers apply, both coal and non-coal.
Okay, so is it your testimony, and I think this is what it is, but let me rephrase, that if there was an MSHA violation that had an environmental consequence to it, it would be relevant for this violation history report?
If it were relevant, yes.
Okay. All right. Didn't have to deal with that objection, apparently. So at this time, I'd like to, for the record, see what happens here. I'll try and admit our exhibit.
Please
Right.
don't show anybody that until we work through it. Any objection?
We're talking about exhibits that haven't been published to council members yet, is that what we're going to talk about?
Yeah, if that's okay at this time.
It is not okay with me to show them that until you made a determination about admissibility.
But I think
I
that's,
mean, for the record, just so everyone knows, it was an attachment to our petition for hearing, so actually the council has already seen it, but that's neither here nor there apparently, I guess.
I didn't have evidence yet.
Right, right.
So, do you have a question for the witness?
I do, yes. Okay, what I'm gonna do is I'm just gonna put that if that helps, so I can find it on my computer. Okay, thanks, sorry. Just because of the lettering and the numbering, I have to find which one it is, so.
Mr. Hearings Officer, would it be all right if I just stood for a minute? My back's getting.
Fine, in fact, I have a note for us to take a break about 2:30. I don't know if anybody wants to take a break now, is it logical?
I mean, maybe we could, I think this will not take much time, I just don't know the process that you want me to try and admit this piece of evidence that apparently I can't talk to the council about, so.
We're almost done with that question.
Yeah, this is actually my last question.
All right, well, let's work on that.
Okay. Okay, so this is our filed Exhibit 14. It was formerly.
Ann is in Nancy.
Yeah, formerly labeled N. And it talks about some MSHA violations that are related to mines that Mr. Jeffrey Hoops owns.
So do you want to, let me clarify what you want to do. Do you want to show that exhibit to the witness and ask the witness questions about it? Is that what you want to do?
I just want the witness, and maybe I can just do this without the exhibit if it would be helpful. I'll see if I can do it that way, and we'll see where it goes just before everyone starts objecting.
Well, I think we're on notice that you're gonna, about what kind of question you can ask. So if you want to pose a question to the witness, don't answer it right away. There might be an objection.
Okay.
So,
Sounds good. So,
Yes, sir, Aaron's administrator.
yeah, Mr. Rutland, just as we were talking about a little bit earlier, you're aware of some Environmental Protection Agency violations. Are you also aware of some mine safety, health administration violations related to mines that are under common ownership and control with Black Jewel?
Not,
Okay, well-
yeah,
is there an objection to that question?
Not yet.
Okay.
not specifically to Black Jewel. I do search the MSHA site just as a industry curiosity periodically.
Okay, are you aware of MSHA being the Mine Safety Health Administration? Are you aware of violations related to Revelation Energy through some of those searches you've done?
Not specifically. Again, I look at that website to see, just in general, what things they're finding or what might be out there as an industry curiosity.
Out of industry curiosity, okay. But you talked a little bit about that if there are outstanding MSHA violations, they become relevant if there is an environmental consequence to those violations, right? I forget your phrase you used. If you could clarify, that'd be okay.
I would say that there are situations where there may be some type of, and I'll use this as an example, a geotechnical failure that might result in a shear on a high wall or something such that there may be unsalvaged topsoil in a small amount that might not have been recoverable. And MSHA would clearly have a safety item with that. And those are the kind of things that we find. But the environmental violation is clearly separate from the health and safety violation in that case.
Okay, and you mentioned that at least for Wyoming mines, you catch some of these violations at the time of inspection.
That's correct.
What do you do for mines that are outside the state of Wyoming? Do you ever catch those violations?
We don't have any authority to regulate outside of the border.
All right, I think I have no further questions.
I guess the next thing we would do is have questions by Black Jewel and then by and then possibly the council members. Do you want to take a break now? Or are your questions going to be perfunctory?
I can't speak for Black Jewel's attorney, but I think we could probably get it done in 9 minutes, so.
Right, so our agreed order was what, Black Jewel then?
Thank you, Mr. Hearing Officer. I appreciate it. Mr. Whitman, I'm going to take you back to your direct examination. And there's a series of questions asked to you, Mr. Cassie there. And the first one, dealing with exhibits DEQ1, DEQ2, and DEQ3. The first question he asked you says, in your opinion, all three of the applications are complete. Remember that question?
Yes, sir.
And is your answer still the same?
Yes, sir, that is correct.
And that answer is yes?
Yes.
He also asked you if all three meet all regulatory requirements. That question?
Yes, sir, I do.
And is your answer to that question still the same right now?
Yes, that is correct.
And the answer to that would be yes.
Yes.
The third one was, if you believe that it should all be affirmed. Remember that question?
Yes, I do.
And your answer is still the same?
Yes, it is.
And you believe that the collateral portion of the bonding is adequate?
Yes, I do.
You still believe that to be correct?
Yes, I do.
So if none of the questions you were just asked change your ultimate opinion that you had?
No, they did not.
Thank you, sir. That's all the questions I had.
Thank you, Mr. Hearing Officer. Hello, Mr. Whitman. I just have a few clarification questions for you. On the issue of ABS checks, are you aware of any law or regulation in Wyoming that requires DEQ to independently investigate every violation that appears on an ABS check?
No, I am not.
Does DEQ possess the resources to do that kind of work?
No, they do not.
On the issue of EPA and MSHA violations, we've gone through the public comment process and folks have had the chance to look at these things. Has the Powder River Basin Resource Council or anyone else for that matter given you documents that show EPA or MSHA violations that give you any pause about the renewal or transfer applications?
No, not at this point.
Last thing, I got confused and I just want to make sure we're on the same page. You were talking about the unknown contingency in the reclamation bond, and there was talk of a 3 to 5% and 5%. I just want to make sure I'm on the same page with you and everybody else is. The 3 to 5% you were referring to, as I is roughly 3 to 5% of the value of the ranches at the time of sale. Is that right?
Yes, sir, that is correct.
The 5% that you were referring to is the 5% of the total area and incremental reclamation bond used to calculate contingency, right?
Yes, sir, that is correct.
All right. Last bit of clarification on the appraisal issue. There were some questions about Black Jewel requesting a recertification in 2018. Does it matter in the eyes of DEQ which entity, whether it's the operating entity or the permittee, requests the recertification?
No, it does not.
Thank you, Mr. Whitland. I have no further questions.
Do the council members have any questions for the witness at this time?
I do, Mr.
Okay, could you say your name for the transcript, please?
This is Dave Bagley. So just some questions relating to the conditional violations that you will see on the ABS. Do you know how a conditional violation would get removed from that list?
Councilman Bagley, the way that they're removed is they come to final abatement or resolution.
Whichever state they have the issue with, and then they would send that information on to OSM?
That is correct.
So then, another question, and we've had a lot of theoretical, hypothetical questions, so I apologize for asking another one. If you saw a conditional violation, could that be something that would allow you to say, you know, I'm concerned about this? I know it's not a shall, you don't have to. If it's outstanding, you have to say no permit block. But if there was a conditional violation, could you decide, I want to put a hold on this permit at this time until I learn more about it?
That is an option that is available. That is a may. That's Councilman Bagley, that's correct.
Okay. I think the other questions I had, Mr. Hearing Officer, were answered among all the other questions that you had.
Lucky, good. Any other council member questions? Would you like to go first? Yeah. Okay, sure. Can you state your name for the transcript?
Yes, my name is John Kwan. Back in the line of questioning regarding mineral rights for the property, for the collateral, without me going through mortgage and all that stuff, if in fact minerals were to be developed on that property between now and the end of the life of the mine, or between now and when you had to actually implement the provision to collect on the collateral, does the state have an authority to negotiate surface use agreements, or does it have some recourse for, say, an oil and gas company to come onto the property and actually devalue the property because they were for something they did? Do you have any rights when it comes to the Black Jewel working with, say, Amoco Production on the development?
Councilman Cora, for me to answer that with any level of certainty, I would have to defer to council and we would have to work through that.
Okay.
in
And I don't worry
advance.
about it, yeah. Just I just need some clarification. There was some conversation between an abstract title office rule and then you relied on the AG. Can you say just a little bit more about that? I mean, did you make a judgment that said I don't need to do go through a title company, I can use CAG.
Councilman Cora, I relied on the advice of council for that decision.
Okay. No further questions at this time.
Let me check in, Madam Chairman, do we still have someone on the telephone?
Yeah, Shane True is here, and I have no further questions.
I just wanted to check in to make sure you hadn't been cut off or anything like that. Okay, so,
Yeah, no, all good. I'm here to.
Madam Chairman, do you have a question?
I do. I have a couple questions. And this is back to statute 406A XIV. It says in the regulation that they're supposed to list all notice of violations basically in the United States. I guess the question is, why is that not actually what happens in those permit applications as opposed to just notice of violations through the DEQ in the state of Wyoming?
Council and Chair Raleigh, that is why we rely on the AVS, because that is the national database.
But that doesn't include violations, that permit application does not include violations in other states, which is what the law says. When was the decision made by the DEQ that those don't need to be listed in the permit application for public notice?
Chair Raleigh, that has been the practice of business in my 30 years of permitting in Wyoming.
Okay. And then my second question, I guess, is pretty much, it's just a restatement of the first one. So that's it.
Any further questions from council members that I missed? Okay, it doesn't sound like there are any further questions for council members. No, at this point, I don't know if I would ask for redirect.
I would.
It's fine, we normally do redirect to the hearings
Do we
like
want to take a break before we go there?
Be super.
Okay, so for DEQ,
Super might be an extreme.
somewhat fast, redirect question.
Absolutely, that'd be fast.
Mr. Hearing Officer, sorry to interrupt. Just a procedural question. Will we have the opportunity to ask a question based on the council members' questions? Because I think there might be related.
Yeah, I think
For some of those.
I think we should give you all, the attorneys for the parties, an opportunity to follow up on the questions that were asked by each other as well as the council members. So, and I would say
I'll go last.
in just rounds, yeah, so go ahead, Mr. King.
No, I said I'll go last. I get to redirect at the end, so why don't we start somewhere else and pick up here?
That's fine. So who would like to go next?
And maybe you'll be bursting with the question, but
You can go.
but we can go to the sequence and maybe that makes the most sense. So we've been going in Powder River, Black Jewel, and then Contour.
I mean, Mr. Hearing Officer, normally only the party who called the witness would be given the opportunity for redirect. I'm unsure like what revolving loop of questions we're opening up here.
Well, I think the most efficient thing to do is to give each one of you attorneys an opportunity to follow up on the council members' questions. And if you have any further questions for this witness, I think you can do that at this time as well. So which sequence would you like to go in?
I really object to giving anybody carte blanche to ask anything they want. That seems like a Pandora's box.
You mean
I
you're
don't want to open at 2:30.
Of the witness?
Yeah, Mr. Hearing Officer, just to be clear, I'm only asking if we have the ability to follow up on something a council member
Right.
asked that may not have been covered either in the direct, the cross, to this point.
And Mr. Cassidy, you want to conduct a redirect examination of the witness, separate from that.
Correct, and that would include questions by the council.
And Mr. Hearing Officer, I would say that Mr. Pope could have asked that question on his cross-examination. And I don't think we can redirect the council's questions.
Mr. Hearing Officer, if I may,
This is for the record, this is Dr. Bagby from council member.
in the past, once the council's done with its questions, they'll get a redirect and we're done. And I know that there may be folks out there dying to answer our questions, but they'll just have to figure out another way to do it.
I'm happy to do it as long as we do it the same way throughout the hearing.
But it's your call, I'm just saying how we.
Well, I'm seeing Ed nodding.
Mr. Harris, there's a question. I don't have any heartburn if we go that route, so that's fine.
All right, so the redirect examination of this witness.
Yes, and it will be brief,
Very good.
as long as you're right. Mr. Ryan, I'm just going to kind of go in the order of subjects that were addressed, and I just have very few questions. First, with regard to your rules and what they provide with regard to the appraiser's determination of fair market value. I believe this is the same in both the new and the old Chapter 11, but the rules provide the fair market value shall be determined, this is the old one. This one, the new one says, by market analysis that may be conducted by an appraiser or qualified agent proposed by the operator. That's the new rule, right? The old rule said that the fair market value shall be determined by a qualified appraiser, right?
Correct.
Okay, so I think you testified you don't get to change and monkey around with the value that's determined by the appraiser.
That's correct.
So if the appraiser says it's worth 26 million, you can't go, I don't like that, how about 20?
That's correct.
All right, now, at the same time, this is an offer of collateral to DEQ. You do have the right to reject the thing in whole, don't you?
Yes, I do. That's
So-
correct.
So if you got a $10 appraisal, you could go, no.
That's correct.
Conversely, what the applicant would really want to do is say it's 100 million.
That's correct.
All right, but you don't have any authority to monkey with the number.
That's correct.
And did you see anything about this appraisal that made you go, I'm not accepting that, that's crazy?
No, I did not.
All right. Now, is the DEQ, if it has to forfeit these bonds, the sureties and the property, are you going to have to pay public money, DEQ money, in order to sell this property?
No, we are not.
Are you going to take that money out of the unknown expenses and pay the real estate agent and the closing costs?
Yes, we are.
Mr. Hearing Officer, just for the record, Mr. Cassidy is asking very leading questions. But I won't object, but it's just, I'm just saying that.
Since it's not an objection, I'll move on.
Go ahead.
Now,
It's fine.
with regard to 2016, you were asked about an appraisal that may or may not have been in place in 2016. Is the valuation of the property in issue in 2016 part of the renewal or transfer applications that are in front of this council?
No, that is not.
In 2016, did you get a document that established the value for the property?
Yes, we did. And upon further recollection, yes.
Did you review that in anticipation of this hearing?
No, I did not.
Did you review any of the materials surrounding the process of obtaining that prior valuation?
No, I did not.
Does it have any relevance to what we're here to do today?
No, it does not.
All right. Now, with regard to the recertification letter, you got one letter and 3 applications. Does that one recertification letter apply to all 3 applications?
Yes, it does.
Does it work for all of them?
Yes, it does.
All right. Now, do you have firsthand personal knowledge of any other violations by Black Jewel or any of its affiliated companies that you should have done something about?
No, I do not.
I have no further questions.
Are we done with this witness?
Yes.
Yes. Thank you very much for your testimony, sir.
You're welcome.
Will this going to be called by another party later in the future of this hearing?
No, I can't imagine he will be, no.
All right, well, thank you.
And your case is finished?
The department does rest at this point. We have no further witnesses to offer.
Very good. So next on our agenda will be the objector's case. I'm saying head nods. And are we going to take a break now? Is that all right with everyone?
That's fine, yeah.
We'll take a break with 15 minutes. Is that all right? Let's go for it. Oh, is anybody not ready? Do we need to shut the door, or are we gonna take a three? Sounds like we're ready, so let's go back on the record. I believe DQ was just rested, and the objective to Colorado River Basin was about to commence its case. Is that right, Council?
That's right.
Very good. Go ahead.
I call our first witness Vanessa Romero.
And would you raise your hand to be sworn? You swear or affirm the testimony you're about to give will be the truth, subject to the penalty of perjury.
I do.
Okay.
All right, thank you. Good afternoon, Ms. Romero. Good afternoon. And again, thank you for being here. I appreciate you showing up and being willing to testify today, so thank you for that. Could you please provide your name and job title for the record?
Vanessa Romero, I am the Records and Data Management Specialist too.
Okay, and what do you do as a records and data management specialist at the DEQ?
I train, we're going electronic with our records, so I will be training operators how they upload documents into our system, how they can look at their permit in our system. I train our permit coordinators and LQD staff how to get into the system, if they have any questions or if the system's slow or whatever. Need a password redone, I do that. I create any data sheets that Kyle may need at his request. I do a lot of uploading, scanning documents from our paper documents to our electronic documents. And I do the fee receipts and for ABS, a little bit of ABS.
Okay, great. You sound like a busy lady.
Yeah.
So you just mentioned you also do the applicant violator system checks we've been talking about today for Mr. Wetland.
I did for about 3 months.
Okay. All right, so let's go back to this DQ Exhibit 8 that we've been talking about. I just pulled it up on the screen again. I'll give you a minute to find it. Are you there?
Yep.
Okay, does this document look familiar to you?
Yes.
Okay. I'll go to page 12 of that document. And do you scroll down and see where you see Wyoming?
Yes.
Okay, and do you see your name listed there?
Yes.
Okay, so you're listed as the AVS user and policy contact for the state of Wyoming, correct?
Yes, here it states that.
Okay, and do you also see your name next to something called conditional violation?
Yes.
Do you know what that means on this
No.
page? You don't? Okay. Do you know if that means if you're the person to call if another state wants to check in about that conditional status?
I do not know.
You don't know? Have you ever received any of those calls in your
No.
time at the agency? Okay, so you've never received a call from another state regulator?
No.
Okay. Do you also enter information into the AVS database on behalf of the DEQ?
No.
No, okay. Who does that at the agency?
I don't believe we do. I don't believe state of Wyoming participates in that.
In the AVS system?
Updating or uploading.
Okay, so you give that information to OSM and then OSM uploads it?
No.
Is that how it works? So how do, to your knowledge, how do Wyoming violations show up in the AVS system? Do you know that?
I don't know.
Okay. All right. I'll see if you know this also. So I asked Mr. Wetland a series of questions about whether this AVS system includes violations from, say, the Environmental Protection Agency. Do you remember that testimony?
Yes.
From Mr. Wetland? Are you aware of whether the AVS system includes those violations?
I don't know.
Okay, I don't know. Just for the benefit of the court reporter, we'll try not to talk over each other. Okay, thanks. All right, Ms. Romero, my main questions for you revolve around an email exchange between you and Mr. Wetland of July of last year. I'm pulling up PRB Exhibit 8, which you can flip to, because I'm sure the text on the screen is going to be small.
Council, this one's been admitted, I'm just checking here.
Yes, it has. Yeah, everything in the binder has been stipulated to or admitted.
Okay,
Yeah.
just checking. That's right.
Okay.
So it's not.
We have,
It's not a mill, I'm not able to pull it up online.
wait a minute, let me, we're on 8.
We're on 8. That's correct.
Not sure.
For some reason. All right.
No.
Just refresh your screen.
No, I'm not sure this,
It is done.
I'm not sure this has been admitted, so,
Let me clarify that. We had a conversation amongst ourselves about just putting this one in spite of some earlier objections. I spoke with Mr. Pope, he agreed that we could put this in, so how about we stipulate right now?
So this be admitted. So this is an additional stipulation since the pre conference, and just exhibit 8.
Yes, sir, I'm sorry that we didn't catch that in our preliminary matters this morning.
That's fine, does the staff have a way to activate that already?
It's up.
Okay.
Okay, thank you. All
You
right.
just refresh your screen.
Yeah, I have it now.
Okay, great. I think we're where we need to be. On PRB Exhibit 8. Ms. Romero, do you remember this email exchange with Mr. Wetland?
Yes.
Okay. Do you know why Mr. Wetland asked you to do that AVS check?
I don't.
Okay. So first up, so you had an email exchange with Mr. Wetland, but then below that, there's an email exchange with a woman named Carol Bilbrough. That's correct?
Yes.
Who is this woman, Ms. Carol Bilbrough?
She was my supervisor at the time.
At the time, okay. And so Ms. Bilbrough actually is informing you that in the email reads, Kyle would like you to do an ABS check on Black Jewel on Thursday.
Yes.
Do you know why that ABS check was supposed to be ran on Thursday?
I don't.
Okay, this email is from a Monday, right?
Yeah.
Okay, and so you waited 4 days and you ran an ABS check?
Yep, on Thursday.
Okay. Is that typical where you would get an email from your supervisor and they would say run an ABS check 4 days later?
Usually they'll just come and ask me that day, but I do get emails requesting we need one ran on this day.
Ran on this day, okay. Do you know if Thursday was a significant date in the permit review process at all?
I don't know.
You don't know, okay. And you testified earlier that you did this for a couple of months, but you don't do ABS checks now?
No.
Okay, who does them now in the agency?
Karen Quigley.
Karen Quigley, okay. So just to kind of wrap this up, is your testimony, you have no idea why you were asked to do this particular ABS check?
No.
On that particular day?
No.
Okay, that's all I have for you. Thank you.
Thank you.
I don't have it, no, you're not up. I don't have any questions for you.
Any questions, Black Jewel
No, Mr. Hearing Officer, thank you. Thank you, Mr. Romero.
and Contour?
No, Mr. Hearing Officer, thank you, Mr. Romero.
Any questions from the council members? Not hearing any. It sounds like you're free to go. Thank you very much for your testimony.
All right, I now call Mark Gorbaczewski to the stand.
Sir, can you raise your hand and be sworn? Do you swear or affirm the testimony you're about to give will be the truth, subject to the penalty of perjury?
Yes, I do.
Okay, you may question the witness.
Okay, thank you. Mr. Hearing Officer, and you aren't hostile, Mark, but do I have permission to treat the witness as hostile for purposes of my examination?
not sure the formality is required, but do you have an objection, counsel?
She just said he's not hostile, so I. I'm sure he was hostile.
She said I was not hostile.
I don't think Mark's hostile either, so, no, I don't see any reason to treat Mr. Rogacheski as a hostile witness. He was a witness for a case in chief.
Mr. Hearing Officer, just to clarify, he is an employee of the Department of Environmental Quality with supervisory functions on this permit application. We're calling him for purposes of examination for our case, but really he is another party's employee. So for that purpose, I would consider him to be a hostile witness.
Yes, did you have a?
One, he hasn't proven himself to be hostile yet in the technical sense of the term. Two, why don't we just ask him questions, and if he demonstrates his hostility, then you can flip the switch.
Okay, I would just say it depends on the kind of questions I ask. But we'll just proceed and maybe see how it goes.
My ruling will be that you may ask questions. If someone objects to the form of your question, we'll address it at that time.
Okay, that sounds great. Thank you. Could you please state your name and occupation for the record?
Yes, Mark Rogoshevsky, LQD District 3 Supervisor in the Sheridan Field Office.
Okay, and so just to clarify, LQD is the Land Quality Division?
Yes, that is correct.
And so that means regulation over coal mining and other kinds of mining permits?
Yeah, I currently supervise my Land Quality Division staff, and we do the permit coordinated duties, compliance, inspections, reports for the northeast portion of the state. So that's Campbell, Sheridan, Johnson, over to Crook and Weston County. So basically any mining comes out of our office.
Okay. So to clarify, you manage and supervise all coal mine permitting done in that office, right?
Yes, that'd be correct.
Okay. And that office has jurisdiction over the 2 mines at issue here today?
Yes.
Okay. As part of that managing and supervisory function, did you or anyone else in your office process or receive any of the financial assurance documents or instruments related to these permit applications?
I am not aware of that.
Okay. Did you or anyone else in your office ever see a copy of the real estate appraisal prepared by Mr. Brockman?
I am not aware of that.
Okay, we don't have to talk about that then. So let's turn to the violations in the applicant violator system.
Okay.
You're a mine inspector, right?
I do that, yes.
Okay, so it's fair to say that you go out on the ground for monthly, quarterly, annual inspections to determine whether a mine is in compliance with this permit?
Yes, I have.
Okay, do you want to say anything else about that role as a mine inspector?
I object to the form of the question. It's too vague to answer. Can you ask a specific question?
Okay, I will. I'll withdraw that one and ask a new one. How many inspections would you say you've done over the course of your career at DEQ? Just an estimate.
Several hundred.
Several hundred, okay. And from all of those several hundred inspections, can you give an estimate of how many cessation orders you have issued to coal mines in Wyoming?
I don't think I personally have been associated with a single cessation order.
So hundreds of inspections, no cessation order.
Well, and those hundreds of inspections, for clarity, are also non-coal, sand and gravel, not just coal.
Okay, that's fine, thank you. Would you consider a cessation order to be a pretty serious thing as a mine inspector?
I haven't given one, but it does take a very severe violation to get a cessation order. You were
Okay.
correct.
How would you describe a cessation order? So a very serious violation?
Again, it's vague, but it would have to be, I would say, maybe you'd have an embankment failure on a sediment pond that would then flow and affect water quality of the receiving stream. Something that would require major cleanup
Okay.
and addressing.
Okay. And what happens if you would, as a mine inspector, you issue a cessation order? Why is the word cessation in there? What does that mean?
Means they have to stop mining. They have to cessate their mining operations.
Okay. Would you agree with me that it's an important part of a permit application process to do this compliance check we've been talking about? Do you think it's important? as a regulator of coal mining in Wyoming?
It's required by statutes.
Okay, but you don't personally have an opinion on whether it's important or not, or?
I do not.
Okay. Were you involved or did you supervise any part of the compliance check for the Black Jewel permit transfer applications?
I did not supervise that, nor did I perform any of the EVS checks.
Okay. Do you have a role to play in determining whether a permit application is complete when it's submitted to your District 3 office?
I have done that, yes.
Did you have a role in determining whether the Black Jewel applications were complete?
Yes, I was the permit coordinator at those times.
Okay. Can you elaborate a little bit on your role and what you determined as part of that review?
Yeah, we make sure that the applications contain the required information. And if they do, we go through the steps of stating they're complete.
Okay. And did you also have a role in reviewing the applications for, I think the phrase the DEQ staff uses, technical adequacy and completeness?
Yes.
Okay. Can you elaborate a little bit more on your role and what you determined regarding technical adequacy and completeness?
Yeah, making sure that once they're deemed complete, it means I have submitted information for each part of that permit that's being updated. And then the technical adequacy would be, to the best of my knowledge, is it accurate and does it meet the law?
Okay, that sounds great. So I was talking a little bit with Mr. Wetland. You might remember this testimony about this phrase statement of qualifications in the rules and that schedule of violations. Do you remember that testimony?
I'm sorry, I do not.
Okay, so I'll pull back up. DEQ Exhibit 2. I think it's page. Page 29.
Table, are you looking at table 1.10-2?
I am, yeah, okay.
There.
Mr. Rogoszewski, do you remember reviewing this table as part of your completeness check and technical adequacy check as part of the permit application?
Yes.
Okay. And Mr. Rogoszewski, you're aware that there's some violations in the ABS system that are conditional, but they're still in the ABS system, correct?
I'm aware of that, yes.
Were you aware of that at the time that you reviewed this table for technical adequacy and completeness?
That we do those at multiple stages, those ABSs. So, but when this went to public notice, I think it was previously stated that it's the last ABS check that we're really concerned about.
Okay. So just to clarify, your role is checking to see whether the permit application has everything it needs to have. I think it's a good way to maybe phrase it. Did you ask any questions about this table to the permit applicant?
No, because when I read this, these are staff that I previously supervised, Mr. King and Mrs. Page, and I was well aware of this NOV and how it got abated. So to me, this table was taken care of.
Okay. Are you aware of the part of the statute and the regulations that talk about common ownership and control?
Yes, generally, yes.
Okay. And do you see any violations from mines under common ownership and control with Black Jewel in this table?
I see Alpha Coal West. That's what I see.
Okay. So you don't see Revelation Energy?
No, it's not provided.
It's not provided.
It's not there.
Okay. So how did you determine that this table is technically adequate and complete if it didn't include those mines under common ownership and control?
I followed our guidance and our procedures.
Guidance and procedures. Can you point me to a particular provision of your guidance and procedures that you followed?
Yeah, we have a guidance document, Land Quality Division Guideline 6A. And it provides in the adjudication section, which I believe this is from the renewal, what is a mine supposed to update and what type of information is supposed to be in there. And we use that guidance document as a checklist.
Okay, this is in the permit transfer application, but is it the same guidance?
It would be the same guidance,
Okay.
yes. If they're gonna update an adjudication portion, we use that as our initial checklist.
Okay, is there any rule that tells you that this violation history table doesn't have to include mines under common ownership or control?
Without having that section of rules, I don't have it memorized, I'm sorry.
Okay,
I would have to review.
okay. Would you generally agree that those rules require information on unabated or uncorrected violations?
I would, without reading them again, but yes, I think it would be a fair summary.
Okay, and I'll ask you the same question I asked Mr. Wetland. Are you aware that there's DEQ rules, are there DEQ rules that talk about conditional violations?
I'm not aware of a conditional, but that definition.
Okay. So just to kind of close this up a little bit, as part of your technical adequacy and review of the permit transfer applications, you didn't ask any questions of Black Jewel or Contura about this violation history table?
I did not.
You did not. Okay. Mr. Rogoszewski, earlier on opening statements, there was a reference to the mines in Wyoming being good operators. Are you aware of any citizen complaints about these mines in, say, over the last year?
Bel Air and Eagle Butte?
Yes, that's correct.
Yes, I am aware of some citizen complaints.
Related to blasting, probably?
Yes.
Okay, so there have been some complaints from citizens recently relating to at least one of the mines at issue.
Complaints, but no violations.
No violations, but complaints.
But no violations.
Okay. All right. Yeah, this is. I have no further questions.
Council? Mr. Rogoszewski, when you make your completeness determination, do you do that in coordination with the folks in Cheyenne, most particularly Mr. Wentland?
Well, yes, and other staff also.
And do you make the determination about what the AVS check shows or doesn't show, or is that Mr. Wentland's job?
That is not my responsibility, that is Mr. Wetland's job.
Okay, I don't have any other questions.
Any questions?
I believe they were just covered by counsel for the DEQ. Thank you, Mr. Hearing Officer.
Contura?
Thank you, Mr. Rogoszewski. I have no questions for you.
Any questions by the council members? Not seeing any, so thank you very much for your testimony.
Thanks, Mark. Yeah. All right, are we ready to go on?
I think so.
Okay, great. I'd call Casey Robb to the stand.
Sir, can you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, subject to the penalty of perjury?
I do.
Okay, you may question the witness.
Okay, thank you. Mr. Robb, could you state your name and occupation for the record?
My name is Casey Robb, and my current occupation is principal accountant for the state treasurer's office.
Okay.
Previously, I was at DEQ as the bonding analyst.
Okay, so to clarify why you're probably here today, you recently left a job at the DEQ, right?
Right.
Okay, and restate that title for me.
Bonding analyst?
Bonding analyst, and what do you do as the bonding analyst, or what did you do as the bonding analyst at the DEQ?
My duties were to receive, review, and process bond instruments And I also assisted the industrial siting division with permits and maintenance of permits, but with bonding,
Okay.
just processing.
Sure, so processing. So to clarify, did you look at like the financial assurance instruments filed by coal companies, like a surety agreement or something like that?
Yes,
Okay, so as the company would submit bonds to the DEQ, you were kind of the person that received them?
that's right.
Okay. So I'm pulling up DEQ Exhibit 2, which should still be open for you, and I need page 44. So it's past where we were before, page 44. Are you there?
Yes, I am.
Okay. Mr. Rob, does this document look familiar to you?
Yes, it is.
Okay, do you see your name on this document?
Yes, I do.
Okay, so, and just for reading for the record, it says, should you have any questions regarding your bond instrument, please feel free to contact Casey Robb.
Yes, I see that.
Okay. Could you explain a little bit about what you did and why maybe you're the contact here on this document?
Yes, happy to.
Okay.
This looks like we received a lot of new surety instruments in anticipation of Black Jewel taking on the permit. And I had drafted this letter. On the back side of that page, I believe it shows a little bit more about what the bonding for the permit looked like. But it was accepting several new sureties and also explaining that the collateral bond would be held on to the permit.
Okay, and what does it mean to be held on the permit?
That's a good question. It was an unusual circumstance, something that I hadn't done before. So I had asked my supervisor, Kimber Wickman, how we should address it, how we should label it, and held on permit seemed like a good way to say that bond would be provided by Contora, but be a bond instrument for Black Jewel.
Okay, so to clarify, it's your understanding, again, we're in the Exhibit 2 that deals with these permit transfer applications and specifically for the Bel Air mine, that Black Jewel proposed and DEQ accepted real property collateral bonding as part of its bond package?
I'm sorry, could you restate the question?
That real property collateral bonding is a part of the bond acceptances that you accepted for Black Jewel, right?
I believe I understand your question.
Okay.
The real property collateral bond would now be an acceptable instrument for Black Jewel.
That's correct. Yeah, so you accepted the real property bond for Black Jewel, but it was held on the permit because Contura still owned the property, right?
I don't feel like I know the reasoning. It was accepted as a bond instrument for Black Jewel, and that's basically. And both sets of instruments are listed because Contura's bonds haven't been released yet until the actual permit transfer is finalized.
Okay,
So,
and Mr. Robb, you're referring to page 45, DEQ
Yes.
Exhibit 2?
sorry, I'm skipping back.
No, that's fine, we can go there. So there's two tables on page 45, right?
Right,
Okay, and as you were just explaining, one is the current bonds for Contura, and one table is the proposed and accepted bonds for Black Jewel.
yes, that sounds right.
Okay, it is your understanding that should the permit transfer be issued by the department, Contura's bonds kind of go away and the Black Jewel table of bonds stays?
Yes, that's right, and it would include that collateral bond.
Right, okay, thank you. Is it also your understanding, or maybe you don't know this, but that title to the property, does that transfer to Black Jewel when the permit transfer is issued? Do you know? It's okay if you don't.
I don't know.
Okay, that's fine. Mr. Webb, in receiving these bond instruments and reviewing them as your bonding analyst role, did you receive it, did you ever see a copy of the appraisal that we've been talking about?
Yes, I did. We handled all the files, the bond files, pertinent information that were related to the bonds. And when it was given to me, usually these confidential pieces of the file are hand delivered and immediately put into the locked bond files. And we also scan them and put them in an electronic file, which is also confidential and only accessible by my understanding by the bonding group.
Okay, so you just talked about that you were the one that received that appraisal. Who did you receive it from?
I don't recall. It was either Kimber Wickman or Mr. Kyle Wetland.
Okay. I think earlier Mr. Wetland testified that only Mr. Wetland and Ms. Wickman had seen it, but you had seen that appraisal, correct?
I believe I did hear that in earlier testimony. However, it might have been that they had their meeting and afterwards Kimber may have given me those documents. I honestly don't recall, but I have seen them.
You have seen them, okay.
Just long enough to file it.
Sure. Did you also read that appraisal?
No, it wasn't my job to review it.
Okay. It wasn't your job, but you're the bonding analyst for the department, or were the bonding analyst, I should clarify.
Yes.
So whose job is it if it's not your job?
I believe it would have been, as Kyle described, that he can accept a bond appraisal, or I mean, real estate appraisal. He has that authority.
All right. So you just received their appraisal, read it, and filed it away in the confidential form that you said.
I object to the extent it misstates his testimony. He said he did not.
I will join that objection.
Okay, so you received it.
Wait, before we skip that.
I'm
What do you
sorry.
want to do in response to that question?
No, that's fine. I'll withdraw that question. That's fine.
Very good.
And I apologize for misstating your testimony, Mr. Robb. But so you received this appraisal and you filed it away in this locked cabinet that you were talking about, I think?
Yes.
Okay, all right. Prior to receiving this appraisal and had you ever processed a real property collateral bond before as the bonding analyst of the DEQ?
No, this was the first time I had seen one.
This is the first time you've seen one, okay. As the bonding analyst for the DEQ, did you have a role in determining whether the department would incur any reasonable costs if the agency had to sell the property to collect on the bond?
No, that wasn't part of my duties.
Okay. To your knowledge, how does DEQ determine those reasonable costs?
I wouldn't know.
You wouldn't know.
I'm sorry, I don't.
That's fine. No, it's fine. It's okay to say you don't know. That's fine. Okay, Mr. Robb, let's go back to that September 2016 date I was visiting with Mr. Wetland about. Do you remember Hunter's original bond package that included a real property collateral bond? Back in 2016?
It was a long time ago, but yes, I remember when it initially came.
Okay, do you remember receiving an appraisal as part of that submission back in 2016?
I don't remember specifically, but I do believe we received
An appraisal?
a value, yeah.
Okay, in a document, okay. So, Mr. Robb, I think we just established, this is the first kind of a real property bond that you had dealt with as a bonding analyst.
Yes,
And how long had you been a bonding analyst at DEQ?
since December of 2015.
Okay. In your opinion, Mr. Robb, is it a real property collateral bond a common type of financial insurance for coal mines in Wyoming?
No, these were the first ones that I had seen, the only ones that I'm aware of.
Okay, the only ones you're aware of. All right. Yeah. So, Mr. Robb, is there anything you want to add in terms of how you receive and review these real property collateral bonds?
Object to the form of the question. It is vague. He doesn't want to do anything here. Let me ask him something else.
Sure, I'll withdraw and rephrase. That's fine. Let me see.
That
if
makes
I
my
can-
job easy. Thank you.
Sure. Yeah, I like to make your job easier. So I like to make my job easier too. Mr. Robb, as the bonding analyst for the DEQ, what did you actually do when you received these real property collateral bonds?
Well, I needed to make sure that all the bonds that we received met the required bond amount. And with the supporting documentation, in this case, we had the mortgage documents from the counties. I needed to make sure that the dollar amounts met what the other paperwork was saying and met all the requirements to fulfill the required bond amount.
Okay, that makes sense. Do you remember when I was visiting with Mr. Wentland a little bit earlier about an abstract company?
Yes, I heard the questioning, but I don't have any input for it.
Okay, so in your review as the bonding analyst for the DEQ, how did you check to make sure the title of the property was unencumbered?
I did not. I trusted the AG's office and Kyle and Kimber to do those parts of this bonding process.
Okay. So as the former bonding analyst, and you used to do this work for DEQ, do you have any concerns about how the department receives or accepts real property collateral bonds?
Object to the relevance of that question. We're here to talk about 3 specific permit applications. It's not relevant to any of the 3 of them.
You want to respond?
Mr. Hearing Examiner, I was just giving him the opportunity to provide additional testimony if you'd like on his former role as the guy who analyzes bonds for the DEQ. I think that's kind of relevant here.
First of all, I have no idea what the question asks for. It's too broad. And he's not here to offer stuff up. It's council's job to elicit testimony from him. And to do that, you need to ask specific questions that are relevant to the issues before.
Well, counsel, do you have a more specific opinion that you would like to, rather than opinions about? Do you have a more specific question than that?
I'll withdraw. I was just giving Mr. Robb an opportunity, so that's fine. All right, I have no further questions.
Okay, I guess we'll be cross-examination.
Yeah, but it'll be real friendly. Mr. Robb, who made up the bonding group? What group of people is the bonding group?
It was a very small group. It was my supervisor, Ms. Kimber Wickman, myself, and we've had an administrative assistant, which was previously Emma Clark, and now it's Frances Tormey.
Was it part of your job as the bonding analyst to take documents from Ms. Wickman or Mr. Wentland and file them?
Yes,
And that's what you did with this appraisal,
yes,
and that's it?
yes.
Thank you.
Cross-examination.
No questions, Mr. Hearing Examiner, and thank you, Mr. Rob.
Stewart, any questions?
We have no questions.
Council members, any questions for this witness? I'm not hearing any, so thank you very much for your testimony.
Thank you.
Thank you, Mr. Robb. And I have no further witnesses at this time.
So do you rest?
I do, thank you. I rest. Or Powder River Basin Resource Council rest, yes.
I guess you say rest.
Yes.
All right, I guess next in line for cases would be Black Jewel.
Mr. Herring, I'm sorry, Council, before Black Jewel goes, we have a motion to make under Section 2 of the Council's Rules of Practice and Procedure. I think it's the most appropriate time to make it, given that the Powder River has just rested. Section 2 of the Rules of Practice and Procedure incorporate the rules of civil procedure, specifically Rule 52 for the Council's use. Rule 52 of the Rules of Civil Procedure allows the Council to essentially decide an issue after a party has been heard. The Powder River Basin Resource Council has been heard on their objections to Contura's permit renewal, which, as y'all heard, DEQ has already approved. The only objection they made was that the reclamation bonding through the use of the real estate collateral was insufficient to protect the state of Wyoming. As I alluded to in our opening statement, they have presented no affirmative evidence that the value associated with that appraisal is wrong, the method of that appraisal is wrong, or that DEQ in the state of Wyoming does not have sufficient protection if the mine were to go under and they need to reclaim this. In fact, you've heard from Mr. Wentland that the state has additional protections in the form of a larger than necessary contingency amount to sell the property, as well as a first lien mortgage on the mineral rights, which have value. There's also been no affirmative evidence presented to the council that that first lien, as it was laid out in the mortgage, is in any jeopardy from anything whatsoever. The reason I mentioned in an opening statement that the lawyer's statements are not evidence is for precisely this reason. Ms. Anderson has questioned witnesses and seemed to suggest that there might be something nefarious out there that clouds title. There is no evidence of that. There is nothing for the council to consider but the speculation of an attorney, for whatever that's worth. Additionally, the only other argument that Ms. Anderson has made that would support potentially doing anything is the lack of an abstract. You've heard from Mr. Wentland that he relied upon the advice of counsel. The important piece here, it was the advice of counsel coming out of a bankruptcy proceeding. Bankruptcy, as you may or may not know, discharges any lien obligations, so that there is virtually zero likelihood that there would be an encumbrance upon this property that would remotely jeopardize the first lien. In addition, Wyoming is a race notice jurisdiction, meaning if you're the first to record, you win. You've heard from Mr. Wentland without any disputed testimony that the mortgage for DEQ is validly recorded and is first in line. So all of the necessary legal requirements to affirm DEQ's decision on Contura's permit renewal are in place and uncontested. Further evidence, further testimony isn't needed for the council to render a decision on that under Section 2 and Rule 52 of the Rules of Civil Procedure.
Can you get a citation of that movie, council? Chapter 1 of the.
It's the Rules of Practice and Procedure, Section 2. It's Chapter 2, Section 2, applicability of the Wyoming Rules of Civil Procedure. Quote for the record, it says, "The council shall conduct all contested case hearings with reference to the Wyoming Rules of Civil Procedure." Section 26 of this chapter specifically incorporates, and it has a list of rules, one of which is Rule 52. If you go over to Rule 52, it talks about how if a party had, and this is 52C, called Judgment on Partial Findings, if a party has been fully heard on an issue in a trial without a jury, which is what we have here, and the court finds against a party on that issue, the court may enter judgment as a matter of law against that party. What we are asking the council to do as the deciders in this case is to enter a judgment that you should affirm DEQ's decision on the renewal of Contura's application, because there is zero evidence to support a contrary decision.
Right, Contour has made that motion, trying to figure out which line I should ask for a response for DEQ.
I'm going to join and say that I could not agree more. Powder River Basin Resource Council had every opportunity to present evidence proving their allegations, and they presented none. I can't say it any better than Mr. Pope, so I'll stop talking.
Mr. Hearing Examiner, for the record, Black Jewel joins in the motion as well.
All right, Council, would you like to respond to that motion?
Sure, Mr. Hearing Officer, I would love to respond. So first of all, there are still a few witnesses left in this proceeding. A couple of those witnesses will be talking about the appraisal. I have a whole long list of questions to ask those folks about the appraisal. So there will be opportunity for us to continue to have this dialogue with you about the appraisal and evaluation of this property. The second thing I would like to mention, again, is this proceeding is only happening, particularly on the permit renewal issue, because the department denied our request for an informal conference. This is the only proceeding that we have as an organization to bring objections to this permit renewal. It would be a violation of our due process rights and opportunity to be heard if you cut us off now and don't allow us to ask questions moving forward of the other party's witnesses. This is essentially a public hearing on a DEQ decision. It's a weird process. It's very complicated. It has a lot of law and regulation and rules of procedure, but it's essentially our only opportunity to talk to you about this. And I feel very strongly that it would be denial of our due process rights, our rights under 406K of the Environmental Quality Act, and your dereliction of your duties under Section 406P of the Environmental Quality Act, if you deny us the opportunity to move forward and ask those questions that we need to ask.
Mr. Hearing Officer, may I have assuming council's done, may I have a chance to respond?
Sure.
I'm sorry, Shannon, if I interrupted.
No, that's fine.
So, Mr. Hearing Officer, two big picture points here. The first, and if I neglected to mention it before, on the permit renewal application, the Powder River Basin bears the burden of proof. DEQ has approved the renewal of that permit. They are challenging that decision. They bear the burden of proof, meaning the ability to ask questions is meaningless. They have to come forward with affirmative evidence, a witness, a document, something besides the statements of their lawyers that says the reclamation bonding in place here does not comply with the requirements of the law. There isn't any of that. And I can tell you, because our witnesses are the ones coming next, that there is going to be no affirmative evidence or statements to that effect. So additional questions simply waste our time, but even so, it still fails to fulfill their burden of proof. The rules that I've cited require the party who bears the burden of proof after they've been done hearing. That's what it's all about. We've heard the objecting party, they've had the chance, they didn't meet their burden of proof. And it's not a dereliction of your duty, it is not a denial of their due process rights. They were heard. They had an obligation to bring forth some evidence. They didn't. And the council, through this process, have given them every opportunity from public comment through now. It is not on us to offer up ways for them to make their case after they've made their case. That's just not the way it should work. Or as unfair as she claims it is to them, that kind of a standard would be more than unfair to us. Thank you.
Council, can I ask you this question? You made reference to burden of proof, and can you point me to in the statute where you're talking about with regard to burden of proof?
Sure, and it's in our briefing, so I would ask you to look there and rather than taking my word on it here, but in a challenge, and I don't think it's in section 406, but a challenge by an objecting party to an affirmative DEQ decision, I think it might be in the 800s. I'm going to see if I can pull up our brief here, but they bear the burden of proof. 406N places the burden of proof on an applicant prior to the decision to grant a permit. That's not what we're doing with the renewal. DEQ has already granted that part. Essentially, what the Resource Council did is appeal that decision to the council. And an appeal to the council, they bear the burden of proof. And
Mr. Hearing Officer, if I could respond to that. So here's the procedure of all of this. Under 406 K, there was a public notice that was sent out by the DEQ soliciting objections. We submitted those objections. Under that public notice, there was a statement in there about you can request an informal conference, and that is exactly what we did. The DEQ responded back to us, and our exhibits show this, that they originally thought there was no public participation rights at all related to a permit renewal. And then they, after some dialogue with me and Mr. Wentland on email, they responded back with a new letter. And that letter said that the director was exercising his discretion to deny our informal conference, at which point I bring this case to you. Yes, the permit renewal was issued in the interceding time. We actually never got notice when that happened. And I would say that this still falls under Section 406K of the Environmental Quality Act. That's our right to request an informal conference. That's our right to request a contested case proceeding. Chapter 12 of the DEQ rules talk about those rights applying to permit renewals. There's not a different set of public participation rules that apply to permit renewals. They're the only ones, they're the same ones that apply to new permits, to permit renewals, to permit transfers. And with that, 406N definitely does apply, and the burden of proof lies with the applicant for that permit application.
And regarding 406N, 406N says the applicant for the permit has the burden of establishing his application is in compliance with this act and all of that. That's what you're talking about.
That is correct.
And you think that burden applies to the hearing that you have requested under K?
I do, yes, and the council has previously found that to be true.
Mr. Hearing Officer, I found the citation for you, so we can clarify for everyone. I was incorrect. It's not a statute. It's even better. It's the Wyoming Supreme Court. The case is Knight versus Environmental Quality Council. The citation is 805 P. 2nd 268. The pin side is page 273, and it's a 1991 decision. And in that case, the Supreme Court said that when DEQ has acted to grant a permit, and that permit decision has been appealed, the person or entity appealing bears the burden of proof. Sorry, Council, we strongly disagree with the notion that we're in 406K and 406N, because those are statutes that deal with things that happen prior to the director acting.
And Mr. Hearing Officer,
Let me finish.
Mr. Hearing Officer, can we
have some thoughts too, Mr. Hearing.
Okay, well, let me finish. You've cited this case, and I'd like you to point me to the language that says in this proceeding for the Environmental Quality Council, the objector has the burden of proof.
I'll pull up the case right now, but that, to summarize, that case was an appeal. There was an Environmental Quality Council decision that came on an appeal from the director's decision. The Supreme Court, in explaining who had the burden to do what, explained that the appealing party, which in this case is the Powder River Basin Resource Council, bore the burden of proving that the permit decision by DEQ was incorrect, because the applicant in that process had already met its burden of proof. The director had said, yep, you've done it. We're going to issue the permit. There was an appeal to the council. The council made a decision, and then the Wyoming Supreme Court clarified that the appealing party bore the burden of proof. And I will pull up for you in just a second the specific language, Mr. Hearing Officer.
Go ahead.
Mr. Hearing Officer,
then we'll hear from the council members as well.
Sure. This particular case has nothing to do with mine permits, and it doesn't specifically address the situation when an informal conference is denied. by the director of the DEQ, what happens then and who has that burden of proof? Again, the way it works in the mining world, the case is irrelevant to the mining world, that we object to the permit, and then we have the right to request an informal conference, which we did. That informal conference was denied, and we come before you. And 406N still applies in those proceedings.
Mr. Hearing Officer.
Well, go ahead.
Yeah, I need to say something and then it'll help me. This whole conversation started by a motion from them for what I would consider to be a quick decision on one aspect of your complaint, which was the appraisal. I'm not getting how the informal conference decision or any of the other publications or any of the other stuff bears on the question this gentleman asked us, or through the hearing officer, can you guys make a quick decision on the appraisal piece of this story? And I don't think I heard you when you were talking, but you have, I think, given me as a council member everything you could possibly give me at your disposal for me to make a decision on that thing in your favor. You're all done, which is why he then says, hey, council, make a decision. So I think at least I'm getting confused, and maybe that's a reflection on me, and I'll accept that. But all this other stuff, to me, doesn't matter. And Mr. Hearing Officer, I'm just thinking that, we're straying and wandering all over the place. And the basic question I think that was asked is, can you make a decision on the appraisal piece now, because they think we're all done talking about it.
Councilman, can you say your name for the record?
John Cora.
Okay, and now, sir, go ahead.
Yeah, this is Dave Bagley, and I don't entirely agree with my colleague, Mr. Cora. The issue, there's several things going on. One, if I recall, this was originally two different dockets. If this had been in a separate docket, I might have another opinion on this, but since we've all wrapped everything together, a lot of what I'm hearing to me could have implications on all aspects of this. So I'm not ready to make a decision on anything yet. But the other question I've got is, I'm not convinced that it is yet the RBRC's duty, because I'm not convinced that the permit was issued appropriately yet. If under K, if an objector came forward and said, hey, we have a concern, and then informal conference was denied in the past, the objector could turn around and then request us to review it before the permit gets signed. The permit has been admitted, but I have to go through and look at this again, and I will, but the timeline of when these things happen, to me, it's not even clear that they have the duty, or they have the duty, burden of proof. And so I'm happy to listen to the rest of this. I got tomorrow blocked off, they're gonna be done by tomorrow, but, and just hear all the stuff. But that's just, I certainly appreciate Mr. Cora's view, because we have seen a lot of things, but that's just where I'm at.
The other council members.
So the last time that the director denied.
I'm sorry, this is.
Sorry, this is Chairman Lowney. The last time the director denied an informal conference, we had a special hearing, figure out whether we had the authority to rule that case. And we determined that we did, and then we proceeded to have that hearing. And I feel like this is the same thing, and that was under K. So that's based on what we've done in the past, that nobody argued about, that's where we are now. They argued, but that's what we determined.
Any other council members?
Mr. Hearing Officer?
As I read, I'm sorry,
Steve Lenz, member. As I read 3511-406K, it says the director may hold an informal conference if requested, it doesn't say shall. So that to me gives the director the opportunity
you appeal. We are here today. Both sides. I agree with Mr. Cora. You're out of point.
Mr. Hearing Officer,
Would you like advice?
And one of the attorneys wants to address this question. Go ahead.
I was just going to ask you, you had asked me for this specific language, given comments from the council, I don't know if you care about that anymore.
I guess I have this question, which I'll pose to the parties as well as the council members. Are you directing this motion to me, the hearing examiner, or to council?
Sorry, one moment.
I
If I may.
hate to interrupt, I'm whispering.
To clarify, Mr. Hearing Officer, sorry, our view is this would be a decision for the council because they are the ultimate decider in this case, and that's how the rule works.
Does Powder agree with that?
I would.
Thank you.
Yeah, it's a very dispositive thing, so.
The attorneys are just saying that they believe that the decision on this motion should be for the council rather than. Am I right about your?
That is right, yes.
Council.
So does the, I have a note here that says, we should take a break about 4 o'clock, and it's almost 4 o'clock, and I wonder procedurally, does the council deliberate on a thing like this? Do you deliberate publicly? Do you want me to go outside for a while?
Mr. Hearing Officer, this is Dave Bagley. All our deliberations must be done in public. However, if we feel we need legal advice from our attorney, we could move to go into executive session and request that legal advice. I don't know if we're there or not, but any of our deliberations are done. And you could be here for those. You need to help make sure that we stay on track.
They're actually broadcast on YouTube if you ever.
I was just told there's a YouTube channel. Okay, so I'm not, it sounds like I'm not going to rule on this motion. And what do we wish to do next?
Mr. Hearing Examiner, this is Mackenzie Williams. I do have one very, very brief piece of legal advice.
I don't know.
To me or? To the council.
So should we go into exec session?
That's up to the council, but I can certainly give my little brief piece of advice to you during that time.
Mr. Hearing Officer, this is just a procedural matter. Typically, the council waits until the hearing officer gives control of the meeting back to the chair.
To the chair, yeah. Okay.
So I'm assuming that there is a procedure to do that, and then the chair give that authority back to you to carry on the rest of the hearing.
Right, so we can take a recess from the contested case hearing. So that is Councilman Cora. Will the parties reject that recess so that the environment quality council can convene and discuss that?
I lobbed a grenade. No, I have no objection.
Okay, so you're turning control back. Okay, I was.
Just one point of order.
Just back to his council.
I'm sorry, I apologize. Mr. Brockman has to leave here today. He has to be in Wheatland for the Planning and Zoning Board that he is on.
And is he scheduled to testify?
I have scheduled to have him here tomorrow. I didn't expect that we'd move so quickly. But he does have to leave today, so
What time is he out, Mr. Hearing Officer, what time is he out to leave?
he has to leave.
I have to leave at 4:30. Our planning and zoning is at 5:30 in Wheatland.
And I'd be shocked if his testimony were finished in I don't know how many minutes he might have whenever we come back.
Okay, well, I'm going to, unless someone has an objection, recess the contested case hearing. And we can allow the council to conduct its business at this time. So we can, and I don't know if the council remains on the record and creates a transcript of what you do, but I'll leave that up to you.
Since it pertains to. Thank you. would anybody on the council like Lindsay's legal advice? Because we need to ask for it if we would like it.
Madam Chair, I move we go into executive session for legal advice.
I'll second.
Been moved and seconded. All those in favor?
Aye.
I think those of us who are not council members have to leave the room, is that right?
Yes.
All right.